Good evening, everyone. So, the other day in the last class, we were discussing about the Contract Act. Actually, it came to an end. Only one topic is left, and that is void agreements. Except for that, we have finished everything. Okay. So, today will be the last topic of Contract Act, that is the agreements which are expressly declared void. Some of which we have already studied in different chapters. Okay, so it is not completely new for you. Once we complete with this topic, we'll start another act of your syllabus, that is the Sale of Goods Act 1930. Okay, so let's get started. We are discussing agreements expressly declared void. Agreements expressly declared void, page number 53 of your module. I repeat, it's page number 53, topic 1.8, agreements expressly declared as void. Am I audible? Am I audible and visible? Okay, so we were discussing about agreements expressly declared as void. There are certain agreements that the law eventually has declared void. Okay, so if you're entering into such agreements that we'll be discussing today, then your contract is void ab initio. That is void from the very beginning. Further, you cannot enforce these kind of agreements. You cannot take them to the court of law and take valid action against anybody. Okay. Reason, it is already declared void by the Indian court. First agreement that is declared void is unlawful agreements. If you are entering into any kind of agreement which is unlawful, that is law does not give you the permission, like for example something which is forbidden by law, like murdering someone, like threatfully detaining somebody's property, etc., etc. If you are doing some works like this, then it is unlawful. Law does not entertain such kind of works. Okay, so if you enter into any contract, like for example I told you that you have to go and kill Mr. B and I will give you rupees 1 lakh if you do so. Now here we are making a contract, right? But here this contract will not be a valid contract. Reason behind is the subject matter of the contract is killing somebody, and killing is forbidden by law. Killing is forbidden by law. So here this agreement will not be a valid agreement. Reason behind this is you are entering into an agreement which is unlawful. Or if you are creating fraudulent activities with someone, or if you are threatening to detain somebody's property, if you are kidnapping, etc., if you are doing entering into any such kind of agreements, your agreement will be void. If you are doing some immoral, if you are doing some immoral activities, like example I have already taken in other class when when we were discussing this topic. The example was, for example, my upper floor of the house is being given on rent to a person, and that person is giving me uh, 10 times more rent, 10 times more rent, because I have given this upper floor to him to make bombs, and he has taken this house on rent so that he can make bombs and blast it in different parts of our country. So here this is immoral. Although I am getting a very handsome amount of rent, but yet it is not on a moral ground. I should oppose this. Okay, so if somebody, if you are entering into any such kind of agreement which is immoral or which is opposed to public policy, etc., then your contract will not be valid. Your agreement will be void. Law has expressly declared such agreements void. Another type of agreements which law has expressly declared void is agreements opposed to public policy. Agreements which are opposed to public policy, that is the public policy, if it is not allowing you to enter into some kind of agreements and still you are entering into those agreements, then then the nature of your agreement will be void ab initio. Like for example, if you are trading with the enemy, we have already studied that you cannot enter into a valid contract with an alien enemy. Alien is a person who is not the resident of India. Okay, so if you are entering into a contract with an alien enemy, it will be void. This we have already discussed. Or if you are like agreements of surpassing prosecution. Sometimes what happens, the prosecution, that is the evidence we are bringing to give evidence, we are surpassing them, that is we are like forcing them to give some to tell false things. Okay, so this is known as what? Surpassing prosecution. If you are doing so, if you are forcefully bringing wrong evidence, or if you are forcing the evidence to hide the reality, then that is also not correct. That is also opposed to public policy. So if you are entering into such kind of agreement, this is known as void agreement. Surpassing prosecution could be in two ways. One is maintenance and another is champerty. Maintenance and champerty. Maintenance means what? When you are not having any financial, when you are helping the evidence financially, but you yourself does not have any interest in the case. For example, I you are bringing me here, you are giving me money to give evidence or to give some what we say, um, the word is like to tell the truth to the court. You are making me come to the court. So here what happens, you, page number beta, it's 53 right now, 54. We started on page number 53, now it's 54. Point number 3, agreements of maintenance and champerty. Agreements opposed to public policy. So basically, if you are helping the litigation process, if you are helping the litigation process financially, if you yourself does not have any interest in it, then it is known as maintenance. But when you are helping somebody financially, when you are helping somebody, someone financially, and you tell him that whatever will be the consequences of the case, if you won the case, 50% of your compensation, 50% of your compensation, you'll be giving it to me. Why? Because I am helping you. So what is happening here is, I am helping you for litigation and I will charge something, and that is 50% of your compensation. When I'm doing it free of cost, when I helping you in financially helping you in litigation, and if I'm doing it free of cost, that is I do not need anything in return, then it is known as maintenance. But when I helping you and I'm demanding something from you, I'm demanding some fruits of your litigation, then it is known as champerty. If you're entering into such kind of agreements, it is also not valid. Okay, if you are well, if you are not like if you are not enough to fight the case and you need somebody's help, then legally nobody can help you. Reason behind this is, if somebody is helping you, if somebody is giving you undue advantage, and that too financially helping you, or etc etc, it is not valid. Such agreements are opposed to public policy. If you are entering into any agreement for breaking somebody's marriage, this is also not valid. Like for example, I told you that you have to keep a spy on my husband so that I find out what is wrong with him and we break our marriage. So I am giving you work to break the marriage of somebody. So here this agreement is also not valid. So if you are entering into any agreement which is for breaking somebody's marriage, it is opposed to public policy, so it is not valid. So these kind of agreements are also considered void. Or you are agreeing to sell public offices. You are not allowed to sell public offices. Only government has the opportunity, only government has the authority, I would say. Only the government has the authority to sell public offices. If you are entering into any kind of agreement, like for example, there's a government office outside my home and that office belongs to the government, but I am entering into an agreement with a person to sell that office, I have no authority, I cannot do that. If I'm doing that, then the agreement between us will be void, because only the government has the opportunity, government has the authority to sell their offices, etc. In restraint of marriage, in restraint of trade, any kind of contracts you are entering into, any kinds of contracts you are trying to enter into is not valid. It is not valid. Okay, like you are stopping somebody to trade. If you are stopping somebody to trade, that is also not valid. Like you wanted to start a new business and I told you, no, you cannot start this business here because I am already doing this. That will not be valid. If I'm restraining you, if I'm stopping you from any kind of trade, then it will not be valid. Okay, but there are certain exceptions, like for example, we were in partnership form earlier. Now you have broken this partnership and you are starting same kind of business in the same locality. At that time, when you were leaving, I can put a clause there that you will not do trade in this geographical boundary. Okay, so this will be valid. But if I'm forcing you not to do business anywhere in the world, then this will not be valid. Okay, so here if you are restraining somebody from doing trade, then it is not valid. If you are restraining someone from marrying, you cannot stop any person who is an adult to marry someone. If you are willing to marry your girlfriend, then nobody has a right to um, oppose it. Okay, if your girlfriend is 18 plus, if you are 21, then in that case you have all the authority, you both have all the authority to get married. Nobody can stop you. Now this does not mean that you'll go to your parents and tell them that ma'am has told that we can get married, so we are getting married today. No, I'm just telling you the legal point. Legal point is, if वो बोलते हैं ना कि लड़का लड़की राजी तो क्या करेगा काजी, that is the thing here. If both are adults, if both are majors, then they can marry. Nobody can stop them from marrying. If you're stopping somebody from marrying, that is also void, etc. So these are certain kinds of agreements which are opposed to public policy. Another, it is on page number 54. Page number 54. I've told this third time. Page number 54, point number B, we are starting now. It is agreement in restraint of marriage. If you are agreeing, that I've already discussed right now, that nobody can stop anyone from marrying anyone. Okay, if a person is an adult, if a person is a having sound mind, etc., all the valid essentials of a person is present in that, then in that case nobody can stop them from marrying. Okay, if you're stopping somebody, if you're restraining somebody from getting married, then it will not be valid. Now you are 18, the person you are marrying is 21, both are valid adults now, though both are legally uh, both have attained the legal age of getting married. So now nobody has a right to stop them from getting married. If somebody is stopping them, then valid action can be taken. If you are telling somebody to stop them and you are giving them money, you have agreed that you have to go and stop their marriage, this is also not valid. Okay, so you cannot enter into any such agreements to stop somebody from marrying who are adults. If you're not an adult, that is if girl is below 18 and a boy is below 21, then in that case you can stop them from marrying. Okay, because that will not be considered as a legal marriage. Legal marriage will only be when both have attained the age of majority. Okay, right now the age of majority has been changed for marriage purpose. It is 21 for girl and I guess 21 for boy. Okay. I don't know the exact change, but I think this has happened. Okay. But for your syllabus, it will be 18 for girls and 21 for boys. So if you are adults, nobody can stop you. Agreement and restraint of trade, that we have already discussed. You cannot stop anybody to enter into any kind of trade, but there are certain exception to these rules. If you are in a partnership, if somebody is opening a shop similar to your business just next to you, who has learned these business skills from you, there you can put a restriction. Now for example, I am a very found street shop. So it is very famous in the city. Now you were working as a halwai. You were working as a halwai at my street shop. You have all the secret recipes of my sweets. You have all the secret recipes of my sweets. Now you decided to leave the job. Now you decided to leave the job. Now, if you leave the job, if you start your own business, then my business will get very much affected. Reason behind this is you will be starting the same business as mine. And that too, you have all the secret recipes that I was selling. Okay, so here I can put a restriction on you, that is you will not open in this particular area in this locality, or you will not use my recipe, or I can patent it. So in such kind of agreements, you can stop somebody from trade. Okay, but except for if somebody has opened a sweet shop who was never related to me, okay, who never knew, who was not my relative, who was not working at my shop, who was not partner, that is he was not related to my business, and he has opened shop just next to me, there I cannot stop him to trade. Okay, there I cannot stop him and tell him no, because I'm doing business here, you go somewhere else and you do business somewhere else, I'll not let you do business here. If we go to market, we see that there are certain same kind of business, same kind of shops in the locality, all are doing businesses, so nobody can stop them. Only when they're in the first situation, that is exceptional situation, where there are partners, or where somebody is working at your place, or where somebody has stolen your recipe, etc., there you can stop them from trading, rest you cannot stop them. Next is agreement and restraint of legal proceedings. You cannot stop anybody to have a legal proceeding. If you are stopping somebody, if you are bribing somebody for not filing a case, then it is also void. Now, for example, I have committed a crime. I have committed a crime. You came to me and you told me I will file a case against you. I will file a case against you because you have committed so and so crime. I gave you an offer that please don't file a case against me because it will ruin my reputation and it will also cost money to you, etc., etc. I have created a long story, and then I'm forcing you, I'm giving you money, or I'm forcing you not to file a case against me. I cannot do that. You can never stop somebody to do any legal proceeding. If you are stopping somebody to do any kind of legal proceedings, that is also void. Now, if I am giving you money to not to file case against me, this agreement between you and me is void. So another agreement that is void is you cannot stop somebody from entering into this what do we say, legal proceeding. Next is uncertain agreements. Uncertain agreements, some agreements which are not certain, which are which will cause some confusion, that we have already discussed in the part of contracts. Okay, when we were studying essential elements of contract, we studied these points. That is, whenever you are entering into any kind of contract, the meaning of the contract must be certain, that is clear. Okay, if I am dealing with 4 types of oils and you come to my shop and you tell me that just delivered 10 liters of oil to my godown, now because I'm dealing with 4 different kinds of oil, so you have to make yourself clear that which kind of oil you want. Okay, You have not made yourself clear. So here there is no certainty. Here there is no certainty. So the contract here will not be valid. The agreement will be void. Reason behind this is the meaning of the contract should be clear, that there must be consensus ad idem, that is meeting of minds. Both the parties must understand same thing in the same sense. If you are trying to say something else, I am getting something else, and then we are doing something else, then this will not be a valid agreement. Okay, the agreement between you and me will be void. Similarly, we have agreements by way of wager. Wagering is, I told you when we were discussing quasi contract. Okay, I've told you that this chapter is a combination of all the chapters that we have already discussed. Most of the topics, most of the points we have already discussed in the past classes. Okay, so wagering agreements we have discussed in the chapter when we were doing quasi contract. Okay, wagering agreement is when you like satta, we can say, like chance game, etc. If I told you that if it rains today, then you'll give me 50 rupees and I'll give you, if it does not, I'll give you 50 rupees. This is a wagering agreement. Horse racing you do, you bet in IPL, you bet in cricket matches, etc. All of these are wagering agreements. If you enter into such wagering agreements, then also your agreement will be void ab initio, because you are not allowed to legally, you are not allowed to enter into such kind of agreements. Okay, so wagering agreements is also void. Agreement to do impossible acts. If you are doing an agreement to do something which is impossible, whose performance is not possible, this also we have discussed earlier. So if you are entering into any kind of contract whose performance will never be possible, then that will also be a void agreement. You tell your girlfriend that please be my girlfriend and I'll bring stars and moons for you. That is not possible. Okay, so girls, don't fall for these. Okay, so this is not possible. So if you are entering into any such kind of agreement where performance will never be possible anyhow, if you do anything, then also those circumstances will not be occurring, then also the agreement between you and the other party is void. I told you that I will deliver the book to you, but for that you'll have to marry my sister. And the fact is that I do not have any sister, or my sister is already married, or I have a brother. So in that case also, here I am giving you, I am entering into a agreement whose performance will never be possible. Reason behind, I do not have any sister. Whom will you marry? Okay, so if you are entering into any agreement whose performance will never be possible, then also your agreement is void. So these are certain agreements that are expressly declared void by the law. Okay, if you enter into such agreements, then your contract will never be valid. Your contract will never be valid, and you will not be allowed to take a valid action in the court of law. Reason behind this is these agreements are expressly declared void. So whenever you are entering into any kind of contract, just make sure these agreements do not come. If you are trying to enter into agreements, into such agreements, then your contract will completely be void, and the nature of your agreement will be void ab initio. Any doubt till this topic? That photo is mine only. When I got married, that is that photograph. Okay. Any doubt till this topic, or shall I start the new act? So here it comes to an end. The Contract Act is completed today. Next topic we'll be starting is Sale of Goods Act. If you have any doubts in Contract Act, ask me here. Else I'll start the new topic. Okay, move to page number 81 now. Page number 81. Page number 81, we are starting law related to sale of goods. Law related to sale of goods. Okay, before starting this act, we have already told you that whenever you are, I have already told you that whenever we are starting any new act, first and foremost thing that should come into your mind is why this act was enacted, when this act was enacted, where the provisions of these acts are applicable. So before starting this act, let us discuss that when did Sale of Goods Act came into force? Why did this act came into force? Okay, so let's get started. I hope you have no doubts till here. The Sale of Goods Act was earlier the part of Contract Act only. Okay, before 1930, all the provisions regarding sale of goods, like if you want to sell, if you want to sell this bottle, if you want to sell some phone, if you want to sell some book, etc., if anything you want to sell, all these were the part of Contract Act only. Why? Because when we talking about sale, it is also a part of contract only, right? We are contracting for selling something. Okay, so earlier before 1930, all the provisions regarding sales were the part of Indian Contract Act itself. But later on, what happened? The consequences, the complications were so high that the Indian Contract Act itself was not sufficient to listen to each and every problem. Okay, so the business complications raised a lot, and then there was many fraudulent activities happening. There were many cases happening, so it was not easy for contract act to handle each and everything. So the makers of the act decided that now we will separate some provisions, like if you do any contract of selling some goods, if you do any contract of selling or purchasing some goods, then now onwards these contracts will not be the part of act. So people will choose that these kind of contracts will not be the part of this. Then what will do? What happen if I deliver the goods to somebody and he did not deliver the money? What will happen then? Where will I go? So it was decided that in 1930, on first day of July 1930, on day of July 1930, a new act was made, which was known as the Sale of Goods Act 1930. A new act was made which was known as the Sale of Goods Act 1930. So what happens on first day of July? All the provisions regarding selling or purchasing goods were detached from the Contract Act, and a new act was made that was known as the Sale of Goods Act 1930. So this act came into force on first day of July 1930. I repeat, this act came into force on first day of July 1930. Now, this is an important question. This will come in. This can definitely come into your exam, that when the Contract Act was enacted or when the Sale of Goods Act is enacted. Okay. So the Sale of Goods was enacted on first day of July 1930. The provisions of these acts were applicable on the country from first day of July 1930. This act is applicable to whole of the country. This act is applicable to whole of the country. Before 2020, I guess 18 or 20, before 2020, yeah, 20. these provisions were applicable only in India except the state of Jammu and Kashmir. Okay, so the provision of sales were not applicable on Jammu and Kashmir, but later on it was amended, and now the provisions are equally applicable on the entire country, including the state of Jammu and Kashmir. If some books are excluding Jammu and Kashmir, then also that is wrong. Jammu and Kashmir is now included in each and every act. Okay, so here we will say that the application of this act, that is the provisions of this act is applicable to whole of the country, including the state of Jammu and Kashmir. Okay, so if something is not right in Rajasthan, it will not be right in Jammu and Kashmir, it will not be right in Kerala, it will not be right in Assam, it will not be right in any of the states. So the provision of this act is equally applies to the entire of the country. Okay, so the act we are starting now is the Sale of Goods Act. So the stress is on word goods. Goods is in inverted commas. Okay, so firstly you have to understand what a good is. What is goods? Okay, when you'll understand what is goods, then only you'll be able to understand the remaining provisions, because here we are just talking about selling and purchasing goods. Goods is coming here again and again. So what is goods? The definition of goods is given in section 7. The definition of goods is given in section 7. It says that there are three things which are excluded from the definition of goods. Rest everything is by default kept into the definition of goods. First thing which are not considered as goods is immovable property. Immovable property. Immovable property is something which cannot be easily detached from earth. Something which cannot be easily detached from earth. If it is detached from earth, then the form will change and it will not be consumable. Okay, like for example, home. Home is not detachable. We have never seen, like for example, today the weather is very good, so it is very cold in Kashmir, so I am taking my home and I'm moving to Rajasthan because it is very cold here, so I'll move to Rajasthan and live here. Then I got bored in Rajasthan, then I left my home and I moved to Kerala because there is raining there and the weather is very pleasant. You have never heard this. Houses cannot be lifted and moved from one place to another. So something which cannot be moved, which cannot be which cannot be easily moved from one place to another. And if you try to move, then the entire property will be damaged. The property will no more be usable. Okay, so those are immovable properties. Immovable properties are not called as goods. Now if you think that I am a property dealer and my work is only to sell and purchase houses, buildings, etc., then this might be good for me. No, then also immovable property will not be part of goods. If you are dealing with any kind of immovable property, that if you are purchasing some house, if you are selling some plot, agricultural land, etc., that will not be the part of sale of goods. It will be governed by the Transfer of Property Act. Okay, such sale and purchase will be governed by Transfer of Property Act, not the Sale of Goods Act. So if I'm selling this house, then here this will not be the part of Sale of Goods Act. Okay, so firstly, immovable property is not included as goods. Second thing that is not included as goods is money. You cannot sell money. Money is not included. Although the old currency, somebody has a habit to purchase old currency, to purchase some other foreign currency, then that is goods. But the currency, the money that is currently prevailing in the market is not goods, Like you have ever heard that I have sold 10 rupees note, I have sold 20 rupees note? No, we have not heard this, right? So money is also not treated as good. Although old currency can be treated as goods, okay, foreign currency can be treated as goods, but current currency that is prevailing in the market, that is current notes and coins which are prevailing in the market, are not considered as goods. They will not be sold, they will not be purchased. Lastly, which is not included in the definition of goods, is actionable claims. Actionable claims is something on which action is yet to be taken. Something on which action is yet to be taken. Meaning of this is like for example, we have a gold. Okay, we have a gold necklace. That necklace belonged to my mother-in-law. Okay, now mother-in-law died, for example, and there are two more sister-in-laws. Now what happens is I had to I'm not audible. I'm not audible. Audio is not coming. Am I audible to everybody, or I'm just speaking like that only? Is it clear now? I'm audible to rest of the people. I think you should check your network. I think you are facing some network issues. Okay, so I was talking about actionable claim. Now there are two more sister-in-laws and the mother-in-law died. So the necklace belonged to mother-in-law. So now who will have the ownership of the necklace? Either me or the other two sister-in-laws. There is a question mark. So the ownership is not clear that ultimately who will be the owner of this necklace. So this necklace will be actionable claim. That is yet here action is to be taken. That is who will be the owner is a question mark. Or sometimes what happens, we put our gold as a collateral security and we take some loan against that. Now if we have not cleared the loan, then until we clear the entire loan, the banker will not give us the gold back. Neither he has a right to sell that. Now I refuse to pay the loan. So the banker filed a case against me. But the case is not yet solved. Now there will be a question mark that the gold necklace will either belong to bank or to me. So this gold will again be a actionable claim. So basically actionable claims are those claims on which action is yet to be taken. Whose ownership is not clear, that who will be the ultimate owner, will he have the right. So these three things are not included in the definition of goods. Rest anything you can by default uh, consider them as goods. Like for example, timber, standing crops, gas, electricity, movable property, etc. Okay, so anything else except from these three things, that is immovable property, money, and actionable claims. Except for these three, everything is included in the definition of goods. Okay, definition of goods, I hope it is clear. So goods is the here goods is the hero of our act. Like in the last act, the contract was considered as the hero. Here goods is the hero. Anything which we are selling, if it is goods, that is if it is coming into the definition of goods, then it will be the part of sale of goods act. If it is not coming into the definition of goods, like if I'm selling house, if I'm selling agricultural land, if I'm selling something on which action is yet to be taken, if I'm selling current currency, then that will not be considered in sale of goods act. That will be the part of some other act, but not sale of goods act. Okay, so these things are excluded. Except for this, everything is by default included in the definition of goods. Okay, next, one more point I have to make clear before starting the act. When in the entire act will be studying 2 points. One is ownership and another is possession. Bar I'll be repeating these two words, that the person had ownership or the person had possession. Now what is the meaning of ownership and what is the meaning of possession? Ownership means when you are the owner of the goods, when the goods belongs to you, when you have all the rights relating to that goods. Now this is my phone. I am the owner of this phone. I am the owner of this phone. Now I have all the rights regarding this phone. I can sell this phone. I can use this phone. I can drop this phone. I can do anything with this phone. Okay, why? Because I am the owner of this phone. I have given money to purchase this phone and now this phone belongs to me. So I have all the rights regarding this phone. So this is known as what? I have the ownership of this phone. Now, for example, this phone belongs to my friend. This phone belongs to my friend. He has given me this phone for using. Why? Because my phone was broken. So he told me until your phone is fixed, this phone is extra. So you can use this. Now I only have a right to use this phone. I have only right to use this phone. I cannot sell this phone. I cannot destroy this phone. I cannot give this phone to anybody else. So this means what? I just have the possession of the good. I just have the possession of the phone. When you have all the rights regarding the goods with you, when you have all the rights regarding the goods with you, that is, you can either sell it, you can purchase it, you can give it to somebody, then you have the ownership of the goods. But when you just have the right to use that, or you just have the right, or the goods are just kept in your possession, or goods are just kept with you, but you do not have a right to use them, there will say you have the possession of the goods. Now my phone I have given to somebody else. It has been, I have forgotten this phone to my relative. That means what? My right now my relative has the possession of the phone. He does not have the ownership of the phone. So there is difference between these two terms, ownership and possession. One is ownership is when you have all the rights regarding the goods. When you have all the rights regarding the goods. But possession is when you do not have all the rights, when you have just a limited right that has been given by the true owner, that has been given by the true owner. There is difference between ownership and possession. Okay, now come to page number 82. We'll be discussing section 2 definitions. We'll be discussing definition now. First definition is section 2 subsection 1, buyer. I hope everybody is clear what a buyer is. Buyer is the person who buys the goods. Buyer is the person who buys the goods. Second is section 2 subsection 2, delivery. Now delivery means voluntary transfer of possession from one person to another. Delivery means voluntary transfer of possession from one person to another. Now if I'm selling this cell phone, if I'm selling this cell phone to somebody and I am voluntarily, that is I am willing to transfer the possession of this phone from me to somebody else. That means what? I am delivering this phone. I am delivering this phone. So delivery is voluntary transfer of possession. When from hands of one person, if the goods are moving to the other person, and that too voluntarily, that is nobody is forcing. If somebody is forcing me to sell this phone, then that will not be considered as valid delivery. Reason behind this is section 2 subsection 2 clearly states that delivery is when you are doing that वॉलंटरली, दैट इज जब आप अपनी खुद की इच्छा से अगर कोई चीज को दूसरे को देते हो, दैट इज नोन एज डिलीवरी. सो डिलीवरी इज voluntary transfer of possession from one person to another. In delivery, possession is very important. If you're not transferring the possession, if you're keeping that possession with you only, if I'm keeping this phone with me only, then here I'm not delivering the phone. I cannot say that I have done the delivery of the phone. Delivery will be when this phone is out of your possession and it has reached somebody else's possession. Okay, so delivery is voluntary transfer of possession. Section 2 subsection 3 states the definition of deliverable state. If I say in layman language, deliverable state means putting the goods into deliverable state. That is putting the goods into such a stage where the other person can come and take that. That is basically putting the goods into saleable condition. Now you came to me and you told me that I want 5 phones. I want 5 phones. But right now only 2 phones are ready with me and 3 phones are yet to be assembled. So I will say that just 2 phones are in deliverable state. That is, you can come and take these 2 phones, but 3 phones that are yet to be assembled are not in deliverable state. That is, you cannot take them. Okay, so deliverable state basically means that it is the process of converting the raw material into the finished goods. When the goods are in saleable condition, that is, you can come and take the goods with you. That will be deliverable state. Then I can say that the goods are in deliverable state. But if any work is yet to be done on the goods, even pricing, even labeling, even packaging, if a small thing is yet to be done with the goods, then also the goods are not in deliverable state. The goods will be in deliverable state when it is completely ready. When you can come and take these goods with you easily, then we will say that goods are in deliverable state. Next is section 2 subsection 4, document to title of goods. Now what is this document to title of goods? The word says that document to title of goods. Title means ownership. It is synonym. You can say title of goods or you can say ownership of goods, one and the same thing. So the documents which shows that you are the owner of the goods, the document which shows that you are the owner of the goods are considered as document to title of goods. Sometimes what happens, now I am sending you something from Rajasthan. Okay, I am sending something to you from Rajasthan. Now here what happens, right now I am not giving you goods. I am not giving you goods because these goods are coming via rail. So I delivered a railway receipt to you. I sent a railway receipt to you. Now what does this railway receipt means? That you'll go to the railway station, you'll go to the railway master and you'll show that receipt to that person, and this receipt means that that person will come to you, that person will deliver those goods to you. That receipt will be a proof, that yes, you are the owner of the goods. So the documents which acts as a proof, which acts as which clearly states that you are the owner, those documents are considered as document to title of goods. So basically document to title of goods are railway receipt, we can say wharfing certificate, we can say bill of lading, we can say bill T, we can say. There are many examples. Those documents which clearly states that you are the owner of the goods, those documents are considered as document to title of goods. Basically the definition is very big. The summary of the definition is those documents which shows that the title of the goods belongs to you. The title of the goods belongs to you. That is known as document to title of goods. Next, section 2 subsection 5 is fault. Definition of fault. Fault means any wrongful default that you do. Any wrongful default you do, that is fault. That is if you are if you are doing adulteration or something like that, that is fault. Okay, so fault is quite clear. 2 subsection 6 says future goods. Future goods will be discussing in future. Okay, so right now I am not discussing this definition because when we'll go to the topic types of goods, then we'll discuss this definition there. Okay, so right now I'm skipping future goods. I'm keeping future goods on future. Okay, so 7th sections 2 subsection 7 goods we have already discussed. Section 2 subsection 8 states the definition of insolvent. Insolvent is a person whose assets are not enough to clear his liability. Now, for example, I have taken a loan of rupees 1 crore. I have taken a loan of rupees 1 crore, but now I am not able to cover this loan. I am not able to provide this cash back to the person from which I have taken. So what happens now? That person has authority. He can sell my estate and recover the money back. Now my estate is just equivalent to rupees 80 lakhs. That is, I will not be able to pay 20 lakhs extra. So here I'll be declared insolvent. So basically, an insolvent is a person whose assets are not enough to clear his liability. When the total estate of yours is not equivalent to the debt you have taken, there you are declared insolvent. So insolvent is a person whose assets are not equivalent to his liabilities, will not be able to clear his liabilities. Ninth is mercantile agent. Mercantile agent also will be discussing in future chapters, but right now I am giving you a brief. Any agent who is any person who will be selling goods on behalf of you is known as mercantile agent. Now I am manufacturing phones. I appointed two people. They will take phones from me. They will go door to door and sell these phones. So here these two people are selling these phones on my behalf. So they will be considered as my mercantile agent. They will be considered as my mercantile agent. Section 2 subsection 10 is price. Price is the consideration of the goods. Price is the consideration of the goods. Now this phone is for rupees 1 lakh. This phone is for rupees 1 lakh. So 1 lakh is the price of the goods. So the consideration of the goods that you are selling is the price. 11th is property. Property means ownership. Property means ownership. Next is quality of goods. Quality of goods means that state or their condition. That is, are those goods are of standard quality? Are those goods consumable, etc. So these are quality of goods. These points are quite familiar to all of you. Okay. So section 2 subsection 13 we have seller. Seller means a person who sells the goods. A person who sells the goods. 14 section 2 subsection 14 we have definition of specific goods. We have definition of specific goods. This also I am skipping for now because we'll be studying this in detail in the next topic. So I have skipped two definitions. One is of future goods and another of specific goods. Reason behind this is I am not skipping it. I am keeping it for future. Okay, when this topic will come, we'll discuss this in detail. Okay, so apart from definition, one more thing that I have to tell you is when we are talking about contract of sale, whenever we are talking about contract of sale, there are two terms which are used in contract of sale. One is sell and another is agreement to sell. When we talk about contract of sale, it includes two terms. One is sell and another is agreement to sell. Sale is when you are actually delivering the goods to another person and that person is giving you money. That is sale. You came to me, you told me that I want to purchase your cell phone. I gave you the cell phone. I gave you the possession of the cell phone. You gave me the money. This is sale. Cash sale is the best example here. Okay, so this is sale where you are when you are transferring the ownership hand to hand, when you are simultaneously transferring the ownership to the other person, that is known as sale. But agreement to sell is when you are not actually transferring the possession. When you are not actually transferring the possession to the other person. You came to me, you told me that I want to purchase your phone. I told you, okay, I'll sell you the phone for so and so rupees. You told me that I will come on Dhanteras and I will take this phone with me on that day. So today there is just an agreement between you and me that I have sold you the phone. But actually, may the possession of this phone is still with me. I have not given you the possession of this phone. Okay, so here it is known as agreement to sell. Here it is known as agreement to sell. So when we talk about contract of sale, there are two terms used in it. One is sale and another is agreement to sell. Any doubt till here? Okay, let's move to the essential elements of a valid contract of sale. So whenever you are selling something, then you should make sure that you follow these rules. If you're not following these rules that we'll be discussing, if you're not following these rules, then your contract of sale will not be valid. First and foremost, there must be at least two parties. Whenever doing a contract of sale, there must be two parties. One is the buyer and another is the seller. And both parties must be different. Both parties must be different. That is, there must be one seller and there must be one buyer. Have you ever heard that I have sold my phone to myself? I have sold my phone to myself. What is this concept? That means I am the buyer, I am the seller. What is happening? There is confusion, right? So these contracts are not valid. Some people do this for tax saving purpose, for embezzlements, etc. Some people do these kind of things, but this is not considered as a valid contract of sale. Whenever we are talking about contract of sale, you have to make sure that there are two parties, and two parties are, one is buyer and another is seller, and both are different person. Next is contract of sale may be expressed or implied. Now, contract of sale can either be expressed or it can be implied. Expressed means what? You came to me, you told me that I want to purchase your phone. Here you are expressing, that is, you are using words. This is a valid contract of sale. Sometimes it is implied also. I have kept my phone as a collateral security and I have taken rupees 1 lakh loan against that. Now, if I fail to pay the price, then in that case, the other person can sell this phone. Here, the contract is implied. That is but obvious. If you are clearing your debts, then the other party has authority to sell that. Okay, so if it is express or it is implied, both the contracts are valid. Next is the subject matter of sale must be good. Now, the contract of sale will be valid only when you are selling something which is included in the definition of goods. If you are selling something which is excluded from the definition, if I'm selling house, if I'm selling some agricultural land, if I'm selling some actionable claims, then I cannot say that I have sold goods. No, I cannot say that. Okay, so if you want your contract of sale to be valid, then you have to make sure that you are selling or purchasing goods only. Goods mean what? Everything which is included in the definition of goods. If you are selling or purchasing something which is excluded from the definition of goods, then it will not be considered as a valid sale. It will not be considered as a valid sale. Valid sale will be only when the subject matter of your contract is goods. Next is there must be transfer of property in goods. That is, you will have to transfer the ownership. If you are keeping the ownership with you only and you are just giving the possession. Now I am just giving my phone to somebody to use. I'm not selling this phone. So here it will not be a valid contract of sale because I am not transferring the property in goods. I'm not transferring the ownership of the goods. I am just giving the possession. So if you want your contract of sale to be valid, you'll have to make sure that you are transferring the ownership to the other person. Just transferring the possession is not enough. With possession, you will have to transfer the ownership also. If you're not transferring the ownership, then it will not be a valid contract of sale. Next is there must be consideration in price. That means what? If you are giving something to someone free of cost, I'm giving you my phone, I'm not taking anything from you, then this will not be a valid contract of sale. There must be consideration, and that is I must sell the goods for some price. If I'm not receiving anything in return, then it will not be a valid contract of sale. So this contract of sale will be only valid when I am receiving something. Next is a contract of sale may be absolute or conditional. Now, this contract of sale can either be absolute or it can be conditional also. Like if I say that I am selling you this phone, this is valid. If I say that I will sell you this phone only if you give me 50% advance. So I'm putting a condition. So this is also valid. You cannot say that no, you cannot put any condition. No, the contract of sale can either be absolute or can be conditions. You are allowed to put on any condition. Mutually, you can put on any condition in the contract of sale. So here, these are certain essentials of a contract of sale. If you stick to these essentials, if you obey these essentials, if you enter into a contract of sale considering these essentials, then your contract of sale will be valid. Apart from that, if you are not sticking to these, if you are breaking these rules, then your contract of sale will not be valid. So today we discussed what when did the Sale of Goods Act came into force, what are the different definitions we already discussed, and what are the essentials of a valid contract of sale. Anybody has any doubt till this topic? Okay, so in the next class we'll continue this act on Monday. Okay, so that's all for today. If you have any queries, if you have any doubts till this topic or in the contract of or in the contract act, you can ask me. I'm here itself, and those who have no doubts can leave the class. Last point of essential was a contract of sale can be absolute or conditional. That is, a contract of sale can either have conditions attached to it or it may be without condition. Like for example, I told you that I want to purchase your phone. So here I am purchasing a phone. There are no additional condition to it. This is a valid contract of sale. Now I told you that I want to purchase your phone, but you told me that I will sell my phone only in one condition if you pay 50% in advance. So here you are putting some condition to it. So sale of goods, contract of sale can be conditional also. If you are putting any condition to it, then also it is valid. So we say that the sale of good, the contract of sale of goods can either be absolute, that is, it could either be conditionless, or it could either have n number of conditions. Okay, so both are valid situations. Clear? Those who have no doubts can leave the class because this is all for today. Okay, thank you everyone. I think you have no doubts. Everything is clear. Okay, let's meet on Monday. We are meeting again on Monday. Till then, have a very nice weekend. Enjoy and study also. Okay. Thank you everyone.